All right, if we can get together, I want to make sure we cover the material and get you back home on time.
How you been? No? You're going.
I debated with myself and did not reach consensus as to whether I should address bullying in this outline. And I decided to do it in a relatively short manner. Although it is not discipline, I wanted you to be aware on the bottom of page 9, there is no definition of bullying under federal law. In Idaho, it's what? Harassment, intimidation, or bullying. So I included from the Idaho statute the definition that's applicable to all children, as I understand it, not just children with disabilities. But paragraph B1 on page 10 is taken from a memo issued by the U.S. Department of Education that's cited on the very top of page 12. And it basically states that if a child on an IEP has been bullied, by the way, that is not the determination of the IEP team. Every school, you have a procedure or a process to investigate allegations, right? You want to maintain that same process. Usually, I've seen it as an administrator or delegate of the administrator is a person who investigates as to whether bullying or harassment actually took place. You want to maintain that integrity of that process. So if the child on an IEP has been bullied, then the team needs to consider if the bullying has impacted the child's receipt of FAPE. And if so, make changes to the child's IEP. So on page 10 is basically taken from the federal memo. Page 11 is kind of Art's additional recommendations for kind of practical steps for the IEP team in carrying this out. And the need potentially to get additional information. I want to point out on page 11, paragraph 4, being careful for the team that you don't place this child in a more restrictive, quote, safer environment who's been the victim of bullying, because that potentially would violate that child's right to be placed in the least restrictive environment. I wanted to highlight, and you could do the reading. I just want to highlight the major points here, but I put in bold print on the top of page 12. So the lesson is learned, and schools have gotten into legal doo-doo, and that is a term, when they relied solely on the state's law regarding bullying. Compliance with your state law or district policy on bullying does not fulfill your responsibilities under the IDEA if that child who has been bullied is on an IEP. Paragraph C1, and I won't get into the details of this, but here was a child who continually was bullied. The parents said every morning became a fight for this. This child did not want to go to school because she didn't feel safe. She started carrying a doll to school with her because the doll was the only one who loved her. The parents sent several emails to the principal that went unanswered. They raised on 2 occasions the fact that their child's bullying she had become what they termed emotionally unable to learn as a result of being bullied. The principal at the meeting said, "This is not an IEP team decision, let's move on." Ultimately, the Second Circuit, after 5 years of litigation, held the fact that we thought this was going to be the case that kind of set the standard. When does bullying raise to the level where FAPE is denied? The lower court addressed that, but it was overturned. The Court of Appeals said the fact that the IEP team refused to discuss it impeded the parents' right to participate in the decision-making, and that in and of itself resulted in a denial of FAPE. When the IEP team refused on 2 occasions. And by the way, they accepted that memo that I referenced, that's cited at the very top of page 12. They referenced that memo as the basis of their decision. So to me, that enhances the importance of that memo when a Court of Appeals, although not Ninth Circuit, when the Court of Appeals adopted that. I also wanted to point out a more recent case from the Federal District Court of Hawaii, where a child had been bullied. The parents requested a hearing. The hearing officer found that indeed bullying denied FAPE in this case. The child had been placed by his parents in a private special ed school. They were seeking reimbursement, and they got reimbursement. So for the following school year, the IEP team called for his return to public school. The parents felt that the IEP did not adequately address bullying. Although he had a crisis plan as part of his IEP, he also had a one-on-one professional called for in his IEP. During oral argument before this court, the school's counsel acknowledged that the IEP could have more directly addressed the prior bullying incidents. This court is troubled by the fact that the IEP both appears to minimize the seriousness of the prior bullying incidents and ignores the school's responsibility for these incidents. The court also agrees with the parents that the student's IEP needs to alert school staff to the fact that bullying is a greater concern for this student than it is with others because of the past experience, and underscores the point here to emphasize its importance as well as to suggest firmly, they don't just suggest, but suggest firmly that including such information would be better and wiser practice. That's different than illegal. Although it failed to present a complete picture of prior bullying, the fact is that the IEP incorporated a crisis plan, alerting staff to the heightened concern, had a one-on-one paraprofessional. There are no magic words that are required to be included in an IEP to address bullying. By the way, the parents argued, and there was an OCR memo on bullying too. What I cited you was a memo from the Office of Special Ed Programs. And OCR gives a series of recommendations if a child with a disability is bullied. The court said that letter is, quote, merely aspirational and does not set a new legal standard. And if you noted, I noted at the end of that citation, it's interesting that they cited an OCR memo and they didn't cite the OSEP memo that addresses students on IEPs. But the court said what was in the OCR memo about suggested steps for schools did not set a new legal standard, but was merely aspirational. I also just wanted to point out the next case, and I wish I had more time, but if you turn to page 14, I underscored what I thought is one of the important parts of this case. The court said, a school cannot be held to guarantee that this child will not be bullied in the future. That's an impossible standard. The parents would like us to impose that standard. As a parent, I want a guarantee. That's understandable. But the school cannot guarantee that, and nor are we going to impose that as the legal standard. As extra credit, paragraph D says, what if the kid on an IEP is the perpetrator of bullying, which has been known to happen? What did we talk about earlier this afternoon? If behavior is impeding that child's learning or the learning of others, the team needs to consider positive behavioral supports, interventions, and strategies. So my question there would be, does this kid have a behavioral component in the IEP? If not, do we need to put one in there? If it's not being effective, do we need to refine it? They seem to also suggest that if the child is the perpetrator, there's more latitude of the team in changing the child's placement. However, the last statement under D1, I said before placing that child in a more restrictive environment, the IDEA requires that the team explain why that's appropriate for that child. And if behavior had not been previously addressed, it's going to be very hard for me to, from a legal perspective, to justify moving that perpetrator to a more restrictive environment if behavior had not been attempted to be proactively addressed through the IEP process. Discipline. Discipline. How many of you have ever taken a school law course? How many of you have taught a school law course? And then the infamous case, Goss versus Lopez, 1975, where the Supremes, it had nothing to do with special ed, where the Supremes basically said, for children who are suspended from public school, they may be so suspended only after they've been afforded due process. And what process is due is dependent on the severity of the disciplinary sanction being considered. Generally speaking, for 10 days or less, informal procedures; for more than 10 days, more formal procedures. That's where the 10-day rule emanated from, the Supremes. And I just cited here that, among other things, any child on an IEP who's being suspended is also afforded the same procedural disciplinary due process rights as any other student. And I cited the Idaho Code 33205, and I've read that, and it gives what? The principal certain authority to suspend, I believe, for 5 days. The superintendent could add to that. The board could add to that, and it talks about informal hearings and formal hearings for more serious removals and expulsions. So I didn't get into what the law requires in Idaho for all children, but it equally applies to kids with disabilities. But now let's talk. Well, first of all, we have an hour left. I'm halfway through the outline. I want to take my cue from you regarding the most, and by the way, we have an hour left. I also wanted to acknowledge the flow chart that Melody put together regarding behavior, manifestation, etc. And again, I happen to be a visual learner, and to me this lays it out nicely. CASE, some of the Council of Administrators of Special Ed, put out a book some years ago called Navigating the Dual Systems of Discipline. And the author of that book is from Utah. And he sent me his flow chart that had 63 different steps. I had to tell him I thought it was accurate. And you have arrows going this way and that way. Have you seen that? Oh, and sometimes I actually have an overhead sometimes, and a slide. And I put that up and it says, this is what you need to do. Are there any questions? I mean, it really is very convoluted. Not only for parents, but teachers, administrators. It really is a difficult system of navigating the process. So I thought Melody did a very nice job of kind of laying out visually a roadmap. So as I talk through this, please pay attention to, and Melanie and I are already talking about maybe she's going to look at maybe some word changes, especially about the in-school suspension as a result of our discussion. But guide me here with the most common issues and concerns you have regarding discipline, because I want to address those first. By the way, I was a former teacher. So when I ask a question, then I see everyone's head go down. I know the game, people.
I actually had a question that was from something earlier. Am I allowed to ask that question?
Yes, you are, especially since you're in charge here.
Okay, I'm not sure. So the question has to do with making sure the folks that are implementing the IEP on behalf of the student are trained. And you talked about seclusion and restraint.
Well, first of all, knowledgeable about their specific responsibilities and trained on how to carry it out.
Right. And so we have had parents in particular want to include training on the IEP. The general conversation is the IEP is for the student, not for the teachers to be trained in a particular area. How do you recommend that a team document or follow through with training and make it satisfactory to the parents to believe that the staff has indeed been trained? What have you seen?
A reading from the regulations. 300.320 A4. Do we have a winner? Don't you think we have regulatory bingo? 320A4. One of the requirements of an IEP, a statement of the special ed and related services and supplementary aids and services based upon peer review research, statement of program modifications, and supports for school personnel that will be provided to enable the child to advance appropriately toward attaining the annual goals, to be involved and make progress in the general ed curriculum, to be educated and participate with other children with disabilities and non-disabled children in the activities described. Supports for school personnel. And there is not a menu to choose from there, but that's where I believe potentially training for staff on how to implement the particular services or interventions in that IEP for that child would fit in. How many of you have seen supports for school staff addressed in the IEP, in an IEP? I see one hand.
Of like man's training, and there would be a conversation about that.
No, I'm talking training how to implement this child's IEP based on the individual interventions and supports in their behavioral component. Now, this person may have had a great deal of experience with similar children. We know based on previous experience, she knows how to implement these interventions. I want to make her aware of her responsibility. Do you have any questions? It'd be similar to that child you worked with last year. Do you have any questions? This person, hi, my name's Art. I mean, in other words, the training for a brand new person who we don't know, who may not have experience, may look real different than this person. And support for school personnel to ensure that they are aware of their specific responsibilities and training as necessary to assist them in understanding their responsibilities and how to implement the IEP.
You said that goes on the IEP.
That could. That's where it would fit. You asked me where it would fit in the IEP. Because the IEP is for the student. But support for school staff is listed in the IEP as support for the student.
Thank you.
By the way, support for school staff does not mean we're going to assign a one-on-one to be with this kid to make my life a little bit easier in the classroom. To me, that would be a supplementary aid and service that would be required by the student and not support by the school for the school staff.
I didn't hear the place for that in the IEP. Would that,
To me, well, as an attorney, I'm speaking as an attorney. I don't care if you write it in the margins. The IEP, but I understand, you know, you have an IEP form that everyone utilizes. But it would be under, and I did not scrutinize your IEP form to this extent. Isn't there a place for support for school staff?
I don't think so. left. Jeff, is there a place on the form for staff? No.
Because it's a component of the IEP and the IDEA.
That's an interesting conversation for us to have.
Discuss.
Yes. Thank you.
We do, under the optional statement.
And you're going to have to crank it up again.
Under the optional statement of service delivery is usually where we describe the people that are providing different services and what their training or background is.
By the way, legally speaking, there is no requirement to identify in the IEP itself the staff responsible for carrying out the IEP. But, I mean, someone's going to have to figure it out, but it doesn't have to be in the IEP itself. And the feds have said that over and over again. Now, as a parent, I would be curious who's going to be working with my child, and I think that discussion certainly is relevant and pertinent, but I can't be found out of compliance because it doesn't say Melanie will do such and such, Charlie will do thus and so, because it's not a required component. And by the way, okay, Art, calm down. I've seen people saying, but it's in our form. Forms cannot create independent legal requirements. Forms represent how to document legal requirements. Or I'll hear this, it doesn't fit anywhere in our form. The law, again, there is to support documentation of legal requirements, not to tell you what you can or cannot decide for a child. Thank you. I feel better. Discipline. Well, let's make this relatively quick on short-term suspensions. Page 15. In essence, you could treat a child on an IEP as a non-disabled child, including for suspensions up to 10 school days in a given school year. There are no special procedures to follow. They are afforded, of course, the same disciplinary due process hearing rights as any child, as we talked about. However, as I said, doing just what is legal is not always the right thing to do. Look at paragraph 6C. So a child on an IEP is going to be suspended for 5 school days for behavior that would result in a non-disabled kid being suspended for 5 school days. However, let's arguably say that in this case, the behavior that the child engaged in is directly related to their disability. May I still suspend the child for that behavior? The legal answer is yes, because no manifestation is required. But I hope as educators, we see the law as a foundation and don't forget good educational decision making. And that if the behavior is directly related to the kid's disabilities, maybe the student does need a consequence, but something other than suspension. But that's up to educational policy decision, because the law allows, doesn't require, allows that kid to be treated as a non-disabled kid for discipline for up to removal of 10 school days in a given school year. No need to conduct a manifestation determination. No prohibition from considering the relationship, but no requirement.
I have a question around
And again,
in the manifestation determination, when you're looking at the direct and substantial relationship, to just any more guidance around when everybody on the team is going to consider that, what specifically we are looking at.
okay, well, first of all, if I could start with, when do we have to make a manifestation determination? Turn to page 16. I want to underscore something that the feds have said, and don't confuse the law with common sense. But if you look at paragraph 7A, if the parents and the school are in agreement regarding a change of placement, and I'm going to add, through the IEP team process, then we don't have to go through all of these procedures. If we're in agreement that this is no longer an appropriate placement for this child and the child's placement needs to be changed or services need to be added, go forth, IEP team. Now, I'm going to add the agreement through the IEP team process, maintaining the credibility of the IEP team process. Paragraph B, and this is a tough one. A manifestation determination has to be made before we impose a disciplinary change of placement. A disciplinary change of placement can connote one of two things. One of two things. The child is up for suspension for more than 10 consecutive school days. That's pretty easy. That's kind of true-false. Kids up for suspension for the remainder of the semester, the remainder of the year, and unless we're in the last week of school, more than 10 consecutive days. That's relatively easy to ascertain. What's more difficult is paragraph B2 at the bottom of page 16, where the child has engaged in misconduct that cumulatively, what does that mean? Adds up to more than 10 school days in a school year. First of all, let me just ask you rhetorically, and it's going to be different in a small elementary school than in a large high school. How does the school keep track of how many days a child on an IEP has been suspended in a year? I, as a disciplinarian, and I do a lot of work with principals and vice principals, usually the disciplinarians. Before I suspend a child, I need to know two things about this child from this perspective. One, is this child on an IEP, by the way, or a 504 plan, but let's set that aside right now. Is this child on an IEP? If so, how many days, if any, has this child been suspended this school year? Because I cannot exceed cumulatively 10 without engaging in another analysis. So let me just ask you rhetorically, how are your schools operationalizing this? And it's going to be different depending on the school environment. I visited one school where they had NCR, I think, is it NCR paper? Where they would, and the sheets of suspensions were sitting on the building administrator secretary's desk. She hadn't had time to enter into the computer system, and there was a stack. So they gathered the data, but it was not accessible. So, again, schools need to kind of keep track of this. Because before you exceed 10 cumulative school days, school personnel, and it does not require the involvement of the IEP team, has to determine whether there is a pattern of removals. By the way, when I also spoke to my friend Jolita, I said, Jolita, I bet you if you sent 4 of your staff members with the same kind of fact pattern into 4 corners of the room and asked them to engage in this analysis, you would get different responses. Because you have to determine whether a pattern exists. Looking at factors, if you look at paragraph B2, is the behavior substantially similar to the behavior that got the kid in predicaments earlier? Factors such as the length of each removal, the total amount of time the child's removed, the proximity of removals. Is this kid been suspended for 10 days and is now up for another 10? Or is it one here, one there, two here, one there, one there? Is it we are in middle of November and they've hit 10? Or are we in the end of May and starting in September? In other words, the further apart, arguably the less likely a pattern exists. I know some states and some school districts, just to make this easier to implement, goes beyond the law, which is not illegal, and says anything more than 10 cumulative or consecutive days will be deemed a disciplinary change of placement. In other words, they're trying to make it easier, but the law doesn't require that, unless you live in one of the states that put it in their code. Idaho is not one. So your state manual follows what's in here in the IDEA. School personnel. If you look on the top of page 17, school personnel, it does not require the IEP team. I have recommended as essential best practice. I didn't say legal requirement. Essential best practice that more than one person makes this decision. For example, the building administrator and the special ed teacher, kind of case manager, someone who knows this child, makes it in conjunction with one another. I think we're going to have a better decision made, and if challenged, a more defensible decision than if one person makes that in isolation, especially in a large high school where I'm a building principal and I may have seen this child, but I don't really know them that well. But the law does not dictate who needs to make that decision. And the decision could consider determines on a case-by-case basis. And paragraph D says that school personnel can consider any unique circumstances. Oh, she's the daughter of the school board chair. I don't want to be, to be honest, I have seen that being considered. But that's not, I don't believe, what was intended. You could look at the commentary under D. Paragraph E, there was a letter to Perry Zirkel, some of you may have heard of him, that used to say that if the IEP team changes the child's placement in the middle of the year, you start the 10-day clock over again. The letter to Biker says since 1997, when there's been a statutory amendment, that no longer is true. The only time you start the clock again is when? The new school year. But the pattern, that's a difficult decision. And I bet you if I gave you a little hypothetical case study and asked to break down about whether a pattern exists based on this case study, I bet you would come back, not everyone would reach the same answer. Whatever your answer is, I hope you're going to articulate how you analyzed it and achieved that considering these factors. And it's not a formula. It doesn't say, if the child has accumulated 10 days suspension within 8 weeks or less of school, it's a change. It's not that easy.
Question, when a student transfers into your district from another district where they've already been suspended, let's say 10 days, we continue with that same window, is that correct?
The law does not address that. Art would concur with that. But that's the law according to Art. I can't cite you a source other than ART. And I am surprised we haven't had some litigation or clarification. Is anybody aware of any? I'm not. Also, paragraph F. Here was a kid on an IEP who was placed in a gen ed classroom. He was emotionally disturbed and gifted. And I like to believe every kid is gifted depending on how you wrap the package. But this kid was, quote, academically gifted. And He didn't like one of his classmates. He didn't like her with a high level of intensity. So he told his friend, here's what I want you to do. So his friend went to her computer and wrote on it while she was out, "Death awaits you." She comes back and sees "Death awaits you" on her computer. Well, she had the meltdown. Her parents had the meltdown. Who is out to get our daughter? And these days, reading the stories we hear going on, we just can't dismiss this as a prank. The kid who did it fessed up. We have no idea what happened to her. But she said, well, Art told me to do it. Art's on an IEP. The school went for expulsion for threatening the life and safety of this student. They conducted a manifestation determination and found no manifestation between the student's emotional disturbance and this behavior. Remember, he's not the one who actually touched the keys, but he had someone do the dirty work for him. So it goes to central office to process the proposed expulsion. And they said, you know, Art's had a pretty good year, and no matter, we're going to have to continue to provide services regardless. We also need to be sensitive to the student here who was threatened, because he needs not only to be safe, but feel safe. So they took Art's little butt, not so little any longer, took from this ABC middle school and moved him to the XYZ middle school. That was 4 miles further from home. IEP was the same. Interaction with non-disabled kids, the same. The school location, different. Ultimately, the Fourth Circuit held that was not a change of placement, that was a change of location. However, there's a footnote there where the court said, we're not always saying that that would be simply a change in location. If that other school was so far away that it would entail such a long commute that the student's education would be impacted, we might view this differently. The school, by the way, provided transportation to that new school that was 4 miles away, so it was not an inordinately far distance. But they'd put that little footnote in, and in a place like Idaho, that neighboring school could be a long ways away over the mountain pass. So just be aware of that kind of disclaimer. But they said, first of all, if it's not a change of placement, there was really no manifestation required. But that didn't stop the court from upholding the manifestation determination. So let's talk about manifestation. I'm getting to your question. On the top of page 18, a manifestation determination is required if there's a disciplinary change of placement, more than 10 consecutive days being proposed, or more than 10 cumulative days when a pattern exists, and if a child is being considered for placement in an interim alternative educational setting. Look at the note. If a kid engages in behavior, actually, if you would, turn to Roman numeral 11. An IAES. So if a child's on an IEP and engages in behavior involving a dangerous weapon on school or on school premises, knowingly possesses illegal drugs at school or school functions, sales or solicits a controlled substance. I've seen oftentimes where a child's medication such as Ritalin is shared with others for a fee. Or has inflicted serious bodily injury, Look at the definition there. That's borrowed from the U.S. Criminal Code. Substantial risk of death, extreme physical pain, etc. It's more than being sassy to the teacher. By the way, if a child engages in that behavior, we're not going to be talking about manifestation determination. We're going to be talking about judicial proceedings. But if a kid engages in one of those behaviors, the school administrator could say, this kid's going into an interim setting. And then paragraph B, the team, IP team, determines where that's going to be for up to 45 school days that could spill over to the next school year. Now go back to page 18. So if that exists, the team has to make a manifestation determination, not necessarily prior to placing the kid there, but whether it's a manifestation or not, the kid could remain there. And the explanation that the feds gave in 2009 says, well, the student could remain in this interim setting for those behaviors, regardless of whether the team needs to consider manifestation, not necessarily before, but right after the child's placed there. And if it is a manifestation, then the team may want to revisit, or the school may want to revisit whether they want to keep the kid there. They could. But unlike a disciplinary change of placement where you cannot go forward if it's a manifestation, for this interim setting, you still have to conduct manifestation, but the kid could remain there even if it is a manifestation. So why do we have to do it? Well, it gives the school then the opportunity to change its mind if they want to. That's hard to kind of process.
My question is seriously bodily harm, it can't just be a threat, because you have kids threatening, I'm going to bring a gun to school and kill you, and other parents wanted us to remove the kid from the setting, and we found that, well, it was only a threat, they didn't actually do.
Well, a substantial risk of death, extreme physical pain, etc. Ultimately, it doesn't show that the kid actually, you don't have to wait till someone is hurt before this is utilized. For example, I got involved in a case where a student threatened some significant physical harm to a teacher. This student had been seeing a private psychologist. The kid was under custody of the state, among other things. The psychologist shared the opinion that this student, every time she made a threat, these weren't words to the wind, she carried them out. So every time she had previously threatened harm to someone, she actually did it. Not in the school setting. In that case, they said, we don't have to wait till someone is actually hurt and disfigured or killed before we invoke this. On the other hand, it's more than, well, this might happen maybe. I mean, in other words, I think the school's going to have its factual ducks. To be honest with you, when we get to that level of safety being jeopardized, if I'm going to err, I'm going to err on the side of safety. The kid still gets services in this interim setting. So it's not a suspension. The kid still gets services. We haven't gotten there yet. But manifestation. So manifestation, the process, how many of you have been in manifestation meetings? Would it be fair to say that everybody's emotional volume is kind of cranked high? Because usually something fairly serious has happened. I've suggested that the school should contact the parent ahead of time to inform the parent what to expect at the manifestation meeting, what questions to be prepared to think about and answer. I think it would behoove the school administrator, the special ed administrator, to meet with the school staff of the manifestation meeting, who will be attending ahead of time, to inform them of the kinds of the issues and the questions, and be prepared to answer the following questions. Also, giving the school staff the ability to vent. Get it out. A real hypothetical. At the manifestation meeting, the school principal started the meeting with, I don't give a good GD what the law says, this kid's out of my school. That was not a positive way to start that meeting. The parent didn't have an attorney at the time. But sometimes it's important to allow people's emotion to vent, but I also want the parent to understand ahead of time to be prepared to answer the following questions. And to some extent, the manifestation question, to some extent, is irrelevant. I'll tell you why. First of all, if you look at paragraph F on page 19, paragraph F and 1 and 2 are the standards. It was a conduct caused by, or did it have a direct and substantial relationship to the disability, or was it directly the result of the school's failure to implement the IEP? So you have to show causation there too. Paragraph G, if there was a manifestation, that's when an FBA has to be conducted unless one had previously been done, and a behavioral intervention plan has to be developed or revised if one had already been done. And the child returns to the last placement that they were in. Now, this is what the law says, and Art's going to add something. The student will return to the last placement unless the parents and the LEA or school otherwise agree as part of the behavioral intervention plan, unless there are other grounds for placing the kid in an interim alternative setting such as weapons, drugs, etc. Do behavior intervention plans determine placement? I think it would be better to read, the student will return to the last placement unless the parents and the LEA otherwise agree as part of the IEP team process. But I'm telling you what the law says, but pragmatically, it's the IEP team that makes that decision. If there's no manifestation, page 20, then the student goes to a regular disciplinary hearing, but there is an obligation to continue to provide FAPE. A couple manifestation cases. Now, I'm old. Does anybody else remember Danny Kaye, the real Danny Kaye? Someone? Oh, you're my people. Thank you. The real Danny Kaye. Well, here's another Danny Kaye that lived in Hawaii and was attending, excuse me, shall we say that the administrator was walking down the hall and heard an explosion from the boys' bathroom. The court at one point talked about a bomb, and another place talked about fireworks. It was a cherry bomb. That, shall we say, as a result, there was exploding porcelain. And I don't want to underestimate the damage that was done to the school. So the administrator hears a boom, walks into the bathroom, and who's there? Just Danny Kaye. Danny, come with me. Danny was taken down to the administrator's office, admitted to the offense. He was going to be suspended for a year. They held a manifestation determination and found that there was no manifestation. His parents challenged that. His parents argued that the school the manifestation determination team had a legal obligation to revisit whether he actually did it because he had ADHD, and the parents said he was paid by his peers to do it. So based on his disability, he succumbed to the pressure of his peers. The team refused to revisit the issue of whether he actually engaged in the behavior that the assistant principal found him to have engaged in. The parents claimed that the manifestation determination team was aware that the student took the blame for the incident in order to get paid. The plaintiffs repeat several times as an improper attempt to resurrect the question of whether the student actually set off the firework. It is not the court's role to determine whether the student falsely confessed to the firework, and neither was it the role of the hearing officer or the manifestation determination team. Instead, the manifestation determination team is required under the IDA to determine whether the actions that led to the potential suspension, as determined by the school's investigation, were a manifestation of his disability. The parents cite no authority, and the court is aware of none, to suggest that a manifestation determination team must review the merits of a school's findings as to how the child violated the student conduct code. Such a requirement would essentially deputize manifestation determination teams and, in turn, administrative hearing officers and federal courts as appellate deans of students. This would be inconsistent with the Congress's intent in streamlining the IDEA. So, it is not up to the team to determine whether the child did the deed. That's part of the school's investigation, as it would be with any student. Let's turn to page 21, a fairly new case out of Bristol, West Virginia, where there was an incident of a child who's on an IEP for ADHD who assaulted a teacher. Up for a manifestation determination. And by the way, the Danny K. court case, the school had a worksheet for the manifestation determination team kind of listing the factors, so everything was followed. There was documentation on everything. This school did too. However, the special ed administrator filled out the form before the meeting, including, not only the background of the student, etc., but was this a manifestation of the child's disability? No. Why? And filled it out. And passed out copies at the meeting and said, this is for discussion purposes. Does anyone have anything that they would like to say or change or add? Court said, nice try. However, that smacked of predetermination, even though the team was given the opportunity to provide input to change what was already filled out in the form. The court also found out that the way the discussion was guided, it was, well, is this the kind of behavior that kids with ADHD typically express? Instead of focusing on the individualization of the student, they talked about kids with ADD and kind of what kind of behavioral issues or symptoms are associated with ADHD. So the court found that this was an improper manifestation determination, ordered the school to conduct another one and provide compensatory education, and we don't want to forget about attorney's fees. Thank you very much. And again, I want to point out the second page on the handout where Melanie's flow chart kind of takes us there. The one point I mentioned earlier that I just want to visit one more time is, I said, to some extent, manifestation, the determination is somewhat irrelevant. Because regardless of the answer, we get to Roman numeral 9. That is to say, services. Let me say this a couple ways. A student can never have their services terminated for more than 10 school days due to misconduct, whether or not it's a manifestation of their disability. to put in a more proactive way. The school must always, no later than the 11th day of disciplinary removal, provide services to the student. So, if we say for no manifestation the kid could go to a regular disciplinary hearing, if you define suspension as cessation of services, really there is no such thing as suspension for more than 10 days. The major difference, if there's no manifestation, where those services are provided is up to the school, not whether to provide them. So if you turn to the bottom of page 21, paragraph 9, and then the top of page 22, I just wanted to point out the Idaho manual, that even though the code allows for all up to 20 days of removal that districts could impose without going to the board, all kids with disabilities must receive services after 10 school days. And there's another provision in the code that this provision will be subject to adherence to federal law. So you can't read that in isolation. And paragraph B underscores the services are not just the continuation of IEP services, but services that allows a child to participate in the general curriculum, although in another setting. If it is not a change of placement, in other words, a kid is 3 days, 2 days, 4 days, 1 day, 1 day, 1 day, and we exceed 10, but it's not a change of placement, school personnel in consultation with one of the child's teachers determines the services to be provided and how. If it is a change of placement, it's the team that makes that determination. Paragraph E says that doesn't mean that the school must duplicate or replicate every course or service that the child has received. Let me give you an example on page 23 of paragraph H. Case out of Virginia. Here was a kid. Anybody know anything about Fairfax, Virginia? Where's Fairfax?
I used to work for Fairfax County.
So it's suburban D.C.
Oh, yeah. About 100,000 students.
But also a fairly affluent.
Yes, and very families who all have a lot of advocates and lawyers and things like that.
Love to hear that. But also the school system is
It's a very, very good school system.
rated top there. This kid was in a high school in Fairfax County in a total immersion Japanese program. He had engaged in some issues regarding selling marijuana. The police were called, and the police basically said, "School, you handle it." I mean, it wasn't a significant amount, but they said, "You handle it." The team decided no manifestation. The kid was placed in an alternative placement. And I know you're going to be shocked. Well, first of all, in the Fairfax school, he was in the total immersion Japanese program, and they had a rich array of extracurricular activities in the school. The alternate program that he was placed in, I know you're shocked, did not have a total Japanese immersion component. Nor did it have all the extracurricular activities that his regular high school had. His parents said, "No way." So they placed him in a private school and sued. You can see what the school said. The school said there is no requirement to replicate or duplicate the program. In essence, the courts have said participate in the general curriculum means allowing the child to participate in those areas of the curriculum that will allow the child to move toward graduation. But you don't have to participate. It's not that particular program or classes that necessarily have to be continued. By the way, those kids still must participate in state assessments under Every Student Succeeds Act. So questions, comments on manifestation, determinations and continuation of services. So that's why I said basically manifestation, whether it's a manifestation or not, the kid continues to get services. The major difference is where. If it is a manifestation, the kid goes back to their last placement unless the parents and school otherwise agree. If it's not a manifestation, the school has an opportunity to provide those services elsewhere. And the kid is not automatically entitled to come back to their last IEP placement.
So a student is placed in an interim alternative setting, and they are to progress in the curriculum
Wait, for one of those 4 behaviors or for?
for whatever reason.
Okay.
It's not the same location, it's not all of the bells and whistles they had before, they're progressing in the curriculum. Is there any rule to how fast they have to progress in the curriculum?
No.
They have to be offered
No, if you-
the same graduation date possibly?
Wait, look what it says on paragraph B on page 22. It doesn't say progress, it says participate.
So it's not a matter of, you're not going to be able to graduate this semester like you would have before, it'll take you another 2 years. That's still progressive.
I'm not aware of any court that addressed that issue per se. I will ask you to turn to page the last paragraph of the outline, a case where a kid was, quote, expelled for possession of a handgun, not a manifestation. He was put in an alternative program. He met graduation requirements, but was not allowed to participate in the commencement proceedings. The court said there is no violation by disallowing him the right to participate in commencement proceedings. He did graduate, he met graduation requirements, but that's really not your question, but that's the only thing that comes to mind. I am not aware of a lot, but I'm not aware of any case that talked about the rate of progression. But on the other hand, I could point a picture or paint a picture. Is the kid given the opportunity to participate in those classes that would allow him to move toward graduation? And if he wasn't allowed that right to participate, I could conceive of a case being built, but I've not seen it. This is the last time I'm going to ask you, who's having fun? Paragraph 10. This is we've kind of previously alluded to this. This is the only place where FBA and BIP are addressed. Paragraph C talks about the IDA doesn't talk what has to be in an FBA or who is certified to conduct an FBA. Do you know what a BCBA is? I mean, I believe special ed acronyms now qualify for a foreign language in some states. A board certified behavioral analyst is not necessarily deemed, they may feel they are the only ones qualified. I'm just curious because I don't know the answer. Is BCBA in Idaho even an educational certification? In most states it's not. You can get a certificate from a national program and so forth, but it's not an educational certification, nor is it required under the IDEA. Paragraph 12, I just want to go through this relatively fast. Paragraph 12 says the kid didn't participate, didn't have guns, didn't have weapons, substantial bodily injury. That definition was not met, but we think the kid still poses a danger to the school. We, the school, could go to a hearing officer and ask for an order placing the child for up to 45 days in an alternative setting. In such case, we, the school, have the burden of proof. And we would have to prove, if you look at paragraph 12A, that if the kid comes back to their current placement, it is substantially likely to result in injury. But I'm going to go down to paragraph 12E. the feds have acknowledged that even though it's not in the regulations, this is one of the few areas where a school could bypass the due process hearing system and go right into court seeking a temporary restraining order or some sort of immediate judicial relief. Let me ask the attorneys in the room. In Idaho, I'm the school, and I'm seeking some sort of immediate injunction or temporary restraining order. When can I get a hearing in court?
It's been a number of years, but I think I applied one time on a Monday and I was in court on Wednesday.
So I thought you were going to say it's a number of years. I'm going, whoa. You know. Yeah. I mean, so basically a day or two. An expedited hearing on this. 20 days. 20 school days. That's not... Your building administrator wants to know what's happening on Monday, not in 20 school days. So that's why I've seen absent parent agreement, schools going to court and not utilizing. Ed, you're a hearing officer. Have you ever had a case of asking for an immediate injunctive relief like this in Idaho?
Yes. Ask Elaine.
Elaine? But I see that, and I do training of hearing officers across the country. That's not the norm. If you get in substantially likely to result in injuries, a pretty high threshold to be able to prove. And so I have seen absent agreement with the parents, the school going right into court because it's going to be a more immediate action. Paragraph 13, we're almost done. Kids not eligible. If my child has never been deemed eligible and now they've gotten into a disciplinary doo-doo, can I assert all these protections we just talked about? The answer is a conditional yes. That is, if the school had knowledge that my child may have a disability prior to the incident. Paragraph 13b, the basis of knowledge. I have expressed my concern in writing to school officials that my child needs special ed. I have requested a special ed evaluation. Teachers or other school personnel have identified or expressed specific concerns regarding a pattern of behavior to the special ed administrator or other supervisory school personnel. If one of those three criteria are met, even though my child has not yet been deemed special ed eligible, I could assert the protections of the IDA regarding discipline.
So under B2, the parent requests an evaluation, what if it was prior and it was previously denied for whatever reason?
Don't name names.
Wait. I think that's a good question. Previously denied. My child's a 10th grader, and in 2nd grade, I requested an evaluation. So I think one of the factors that I would use in my analysis is recently, 2 years ago, 5 years ago.
No, talk about in the last year.
And secondly, did the school provide the parent written notice of refusal along with their procedural safeguards? Did the parent exercise any of those procedural safeguards challenging that denial? I think all of those factors would go into my analysis. And it would be, what would they teach us to say in law school only? It depends.
So you're saying call Elaine?
No, I think it would depend on the answers to those questions. By the way, I haven't gotten it. If you turn to the top of page 29, paragraph E and F. Well, actually, it's not on your top. It's probably, is it on your bottom of page 28? Because I adjusted the outline a little bit, so my copy is a little bit different. E and F, the letter to Jeff U. Dean. If the parent refused to consent for the initial provision of services, you know that before my child can first get IEP services, I have to give consent, written permission. And if I don't, the school cannot challenge me. If the school offered services and I don't give consent, the disciplinary protections of the IDA don't apply. Paragraph F. As of January 1st, 2009, I have a right to unilaterally say, oh, cut those special ed chains that bind my child. I am revoking consent for continued participation in special ed, and the student must be exited. The school cannot challenge my decision. In such case, the student will be deemed not to be protected by the IDEA for disciplinary purposes, even though last week they were. And the feds have said they could be treated as a general ed student. I thought we would see some litigation on that. To the best of my knowledge, we have not. Paragraph G, general ed interventions. Here was a kid who had ADD, was referred to the gen ed, what do you call it, the problem-solving team, who was providing some interventions. They were not working as successfully as they hoped. The student was then referred to an outside mental health agency to get additional assistance. In the meantime, the kid engaged in some serious behavior, if I recall correctly, assaulted a staff member and a student. The court held that the kid was protected by the IDEA. When the school made the referral, after going through general ed interventions, to an outside mental health agency to get additional assistance, based on these facts, there was sufficient reason for the school to believe that the student warranted an evaluation, even though the parent had not requested it. The court said the school then should have followed the IDEA process. We're coming to the end. All I want to say in paragraph 14, the law had to actually be amended. There was a situation out of Wisconsin. A student on an IEP held a knife to a teacher's neck. Another faculty member saw this, what happened, subdued the student. Unfortunately, nobody was hurt. The police were called. The criminal court in Wisconsin dropped charges saying before the police were called, the school should have conducted a manifestation determination. Will the following people please report for an emergency manifestation determination? And there was another case, not quite as dramatic, but out of Tennessee. If we don't like a court case, there's two options. One, we appeal it, or two, we change the law on which the court used to base its decision. The latter occurred, and the Congress changed the law saying there's nothing in the IDEA that limits or prohibits a school from calling law enforcement when there is a crime being committed. No manifestation, but it does say that copies of the education records then have to be transmitted. Paragraph C says, pursuant to FERPA. So you call the police because some significant, and then you get a minivan and you're rolling in boxes of education records. What's the police going to say? What do you want me to do with these? And there was a real debate even in the parent advocacy community about this. The main purpose is we want the police to understand that this child has a disability so they can decide what action to take in processing this. Other parents I've talked to said, it's really none of their business unless I determine that they should have this information.
We've had that complaint. That's come through as a complaint.
So paragraph C said that we have to follow FERPA, and absent parental consent, FERPA says we need to get a subpoena or if state law allows. Or if there is an emergency situation. I would work with the parent to determine what records, if any, to provide police if they get involved.
Art, can we talk about what is meant by records? I mean, what about just giving some information, like the student has
A
been.
conversation.
Yeah, conversation. Students on an IEP seems to be very frustrated whenever somebody gets.
The law itself says copies of special ed and disciplinary records are transmitted. Copies of records, to me, contemplates more than just a verbal summary. But like I said, then they add, in the regulations then, they added C, that is pursuant to FERPA. So if I was a school and we had to call the police and this child happened to be on an IEP, I would want to have a conversation with the parent about what records we collectively deem to share in a non-emergency situation. And in an emergency situation, we have to deem what records are necessary to address the emergency. Very limited. Example, here was a student who was on an IEP because he was deaf. He held himself in a locked classroom and texted that he had a bomb. The police were called. Well, they needed to be notified that the student was deaf, so if they're yelling out and the student doesn't respond, instead of saying, you want to see the last reevaluation report? In other words, what information from the student's records does this law enforcement need to know to respond to the emergency? And in such case, you don't need parental consent.
Art, I understand the district may call police, and you use the example of a knife against a teacher's throat.
Well, that was the case.
I agree. I understand that. What I think frustrates me is going back to this morning and the responsibility that the district has to ensure people, including resource officers, are aware of what's required in the student's IEP. And so you get
Well, especially regarding restraint and seclusion.
you get a kid with full-blown autism who gets upset and flings a handful of pea gravel, and the classroom teacher decides, I'm going to file assault charges. And they call it's that interpretation of calling the police. The nearest policeman is our resource officer. So
And in Vermont, we may not even have that.
the resource officer comes in and it just gets completely out of hand.
And that's why like I said, I've seen children in kindergarten handcuffed. I shouldn't say I've seen it. I got involved in a case where that occurred. I did not observe it. I'm sorry, Mont, go ahead.
The question I've had, and maybe this is more appropriate for tomorrow, but if a kid is on school property and the pea gravel being thrown hits a teacher who's being paid to be on school property, is being paid in their role, is on the job site, and then the district says, well, you're welcome to file charges personally.
Well, first of all, I don't file criminal charges against the student. I could report a crime, an alleged crime, but it's up to the district attorney ultimately. I could file civil assault charges, but I don't prosecute someone for a crime as an individual. And I do think there are some challenging behaviors. But I have seen some people overreact in the heat of the moment, where it strains common sense, if not the law. I don't want pea gravel thrown at me. On the other hand, I mean, that's a little bit different too than someone, the other example I used, the case in Illinois where the kid took some sheet metal and tried to slash the teacher. I think ultimately, in analyzing this, they would look at, I think that's one of the reasons a lot of the parents in the FC community wanted the transmission of records to the police, so that they would be able to factor that in determining where to take it from there. But I can't file a criminal charge. It's not up to me to prosecute.
I understand that. I guess, to me, the question revolved more around, where does your role as an employee of the school district charged with providing services to this kid begin and end, and your personal decision-making begin and end?
And I think there's components of legality, of ethics, of commitment. The only case that I am aware of, and I know I'm keeping you after school, but I want to respond to Mont. There was a case out of Wisconsin where a child was on an IEP. Some real challenging behaviors. The behaviors really improved with a comprehensive behavioral plan, and the parent also took the child to see Dr. Freud, a child psychiatrist, who administered some meds, and the school saw a real improvement in the child's behavior. The parent, without conferring with Dr. Freud or informing the school, stopped administering the medications. The kid came to school and had, shall we say, an outburst in the classroom. The teacher called a special educator who came to the classroom and put the child in a hole